Good morning, everyone. Welcome to the Utah Court of Appeals in virtual session. We've been doing this for some months now, and I don't know if either or both of you have had the opportunity to argue via WebEx, or if this is your first time. But it has gone surprisingly smoothly. Occasionally we'll have a technological glitch. We're happy to kind of pause and start over and rewind, as it were, if any of us miss something. But otherwise, the rules are about the same. We allow 15 minutes aside for oral argument. Appellant can save time for rebuttal and apparently has elected to reserve 5 minutes for rebuttal. Rebuttal is, of course, limited to addressing points that were made by appellee. It's not appropriate to reserve issues to introduce for the first time during rebuttal, and we enforce that fairly strictly. If each time counsel comes on screen, you will state your appearance for the record, or in the case of appellant on rebuttal, restate your appearance. It helps us later, if we have occasion to listen to the audio record, to remember who is saying what when. We've also found that it's very helpful if the attorney who is not arguing will go off camera so that we're not distracted. That also leaves you entirely free to moan and groan and roll your eyes and shake your head without concern that we will be annoyed by that. The other thing that's quite helpful is, and this goes for the judges as well as the attorneys, when you're not speaking, if you will mute your microphone, it does help with the quality of the audio for everyone else. We will try and remember to raise our hand when we're about to say something. You don't need to stop mid-syllable, but when you come to a rather prompt, convenient breaking point, if you would then take our question, we would appreciate it. Any questions about any of that? Very well, then we will hear appellant's argument.
Thank you, Your Honor. I appreciate the time that the court has taken to review the materials. I wonder, before I start addressing my issues, if there are any questions specifically at the outset.
Sure, I have one. I thought there was a reference in your brief to setting aside a lack of disclosure of witnesses, that there was also a lack of disclosure of documents.
Yes.
Okay. It didn't appear to me, and maybe you can help us out here, that your principal brief was all too particular about what we were talking about and why that particular document should have been disclosed and how its non-disclosure was prejudicial. Could you clarify that or point me in your brief where I missed it? Because clearly the main thrust of your argument is that the witnesses themselves should have been disclosed, correct?
Yes, that's correct, Your Honor. And I think in the proceedings below, which I was not a party to, that was the main thrust of the trial court's focus and my client's focus as well.
So was there a document?
From the admission of documents that was included in the transcript, and I can't give you a page citation to that in the record, but it indicated there were numerous photographs, there were Facebook postings, there was a report from this private investigator, and there was a letter that was found in the garbage can. Those items were introduced and accepted as evidence.
Okay.
What do you say to the suggestion from the other side that, oh, well, not part of our case in chief, that was all just impeachment evidence?
Well, again, I think it's a novel approach, Your Honor. But if that's the way litigation works, I think I've been doing it wrong for the last 15 years. The problem is that right, the rules talk specifically about evidence that's solely for impeachment. And while the Utah appellate courts haven't clarified what that means in the state of Utah, right? We referenced some of the different jurisdictions that have split on that and how they've interpreted it, but it's always been very strictly that word solely is important. There's witnesses that can testify. There's evidence that can be, in fact, most evidence and most witnesses can fill multiple purposes. They can provide substantive testimony and evidence, as well as impeachment testimony or evidence. But that clarifier, it has to be information that's provided solely for impeachment. So if that evidence has any substantive effect, that's evidence that should be disclosed initially, certainly, because again, it all goes to the purpose of the rules, which is to allow people to prepare for this case. One of the issues that I see in this, Your Honor, is that right, all of the information that was provided to Kathy was after the discovery deadline. She had the 28 days before trial to try and get ready for it, which in all of the cases that I found, that there aren't a lot, right? Most of them are dealing with damages, evidence, and things like that. But that was a huge thing. The fact that the parties, it was beyond the discovery, and the parties couldn't respond to it. That was always evidence of harm. It seems that the trial court said Kathy had to try and establish that failure to disclose was harmless. Which again, I didn't find in the case law that the requirement, the burden was on the party who was looking at the harm to be able to justify her harm.
Mr. Ahlstrom,
yes.
Here in this case, it was Mr. Johansen's petition to modify alimony, right?
Yes.
And it was his burden to prove the cohabitation.
Yes.
Which would engender a modification of that alimony. How could you just talk a little bit more and discuss how her testimony was the substantive testimony that Mr. Johansen basically offered or proffered in his case in chief, correct?
Yes.
To prove his case. And so how can if everything that came after was impeachment evidence intended to discredit her testimony and to reduce the effectiveness of her testimony, how did he prove his case?
Well, I have that same question. Looking through and reviewing the findings and reviewing the record from the hearing, it appears that the court relied very heavily on this testimony that was called impeachment to determine substantive facts that were necessary for him to prove his case. And so again, and I hope I'm not conceding that he should have been able to call Kathy as a witness. Again, she wasn't right. None of that was disclosed. The rules, 26A, again, seems pretty straightforward on its face that you have to disclose all of the witnesses that you may call in your case in chief, and so it's 26(1)A. I think 1A, right? But it says that you have to disclose any witness or any person who potentially has information, unless that person is solely for impeachment, and you have to disclose any witnesses that you may call in your case in chief. And it references opposing party. So the language of the rule, as I read it, says you have to provide that information, and if you don't, then you appropriately should be barred from presenting that information in your case in chief. And so I don't think that impeachment issue even becomes an issue, because there was no witness disclosed and there was no witnesses then that should have been able to be called. Kathy's motion to dismiss, because they weren't going to be able to present any evidence, should have been granted at that point. And the court acknowledges that there's no compliance with 26A and the initial disclosures, but then says, well, the trial court says now Kathy has to establish some harm, which even on the record, I think she did, right? She talked about the fact that she didn't know what any of these other evidence or testimony was going to be, and she struggled to be able to meet it. She had 28 days to be able to prepare, which under everything that I've read about the rules of civil procedure, that's exactly what they're designed to prevent, is this idea that all of a sudden I've got 28 days now to get ready to try and meet all of this information. So that it's just under the simple approach of the rules, the court shouldn't have even gotten to the issues of whether there was cohabitation or not, because Colton didn't provide anything up front that would allow him to call any witnesses at all. And because of that, no witnesses should have been allowed. And clearly, the fact that Kathy was not able to have sufficient advance notice to be able to evaluate her case or do any of those things. I mean, not even to be able to say, wow, this looks really bad, so I need to cut my losses. She didn't even have that option. And so there's I think, in spite of the trial court's finding below, there's clear evidence that she was harmed. Yes.
Mr. Holstrom, did she have the investigator's report, the photographs, copies of the Facebook postings, the letter retrieved from the garbage can? Did she have all that stuff 28 days in advance of the trial?
Yes, that was the information that she received as the pre-trial disclosures.
So I'm not sure that the case turns on this, but if it does, in a fairly straightforward case like this, it seems like a month would be adequate to pull together letters that were sent with other address. Think about the photographs and if they were contrived, and if that was the one time when he was taking care of the house for her when she was out of town, etc. I think you would be in a much better position to make the argument you do if all this stuff were sprung on her at trial. And I'm not sure that the court was correct in sort of considering that the burden was on her to prove harm rather than on the other side to prove harmlessness. But if that ends up mattering, tell us a little bit more about how a full month would not have been adequate to think about, deal with, and consider how to refute that evidence.
Well, my response to that, Your Honor, would be, if that is the case, then I think we have a whole lot of superfluous rules. If a month is adequate to be able to address any of these types of issues, then I don't understand why the rules allow for any longer time period. I think, one of the issues that the trial court raised, and again, I hope I'm okay, Your Honor. I've got the zeros at the top, so
That's
I hope I'm okay.
questioning. You'll have your full time on rebuttal. Putting you over your time was primarily on me with my remark in question as you were down to mere seconds. Okay,
and I just wanted to make sure that the big hook wasn't going to pull me off or something. So, and now I have to get back to where I was. The the fact that I think Kathy pointed out to the court that she would have hired counsel, but the court acknowledged, right, that she probably wasn't going to be able to find an attorney who was going to be able to help her 28 days before this trial. But just the fact that she scrambling, trying to do this on her own without the benefit of counsel, and trying to gather up this information to be able to rebut these things that were presented to her for the very first time. And that was the very first time she knew that her teenage daughter was going to be a witness against her, that her daughter had been taking photographs. And again, having reviewed the transcript, I think that Kathy made a noble effort, considering the fact that she only had 28 days, Your Honor. But I think the very purpose and the existence of the rules of civil procedure suggest that as a profession, we have determined that 28 days before trial is not adequate time to be able to prepare and to present counter evidence.
And thus the rule requiring the initial disclosures and their supplementation, and the general rule that failure to comply with those requirements will preclude the witnesses from testifying, etc.
Yes.
Okay, very good. I think we understand your position. We'll excuse you from the screen now and hear from the other side.
Thank you. Good morning. Can you all hear me okay?
Yes.
Okay, thank you. And of course, I learned long ago to prepare my arguments with the expectation of questions, so I will count on those. But the way I perceive, the way I see Ms. Johansen's arguments in this appeal is twofold. There are two issues she raises: the non-disclosure, the no initial disclosures, and there is no dispute that there was no initial disclosures that were provided. But that the trial court's decision in finding harmlessness to disclose Kathy as a witness warrants reversal. The second is a factual inquiry into the trial court's findings, challenging the trial court's actual findings. And so I want to note that as an initial matter in my argument that I don't believe the impeachment argument is properly preserved. So Ms. Johansen was pro se for all her pretrial matters in the actual trial, but after the trial, she retained counsel who filed a motion to amend the findings, which I essentially reviewed as a 60B motion to set aside the judgment, because he was not asking to amend the findings so much as to change the judge's mind. But the counsel's sole focus in that motion was to convince the district court to set aside its findings based on the initial disclosure argument that counsel's made today. There was really no argument at all about the impeachment question. So this is in 676 and 677 of the record on appeal, the transcripts of that hearing. And the trial court asks, isn't the whole linchpin of your motion the fact that respondent wasn't identified in 26A1 disclosures? Isn't that the whole linchpin of your motion? Yes, that's what it all comes down to. The court, because I don't hear a lot of argument as to whether petitioner had the right to call rebuttal witnesses or impeachment witnesses rather. Yes, and then counsel replies, I think the linchpin, because we never get to the other stuff, is that we are here with no witnesses should have been called. There were none disclosed. So under Rule 26, none should have been permitted to be called. There isn't a way for Mr. Johansen to proceed with his case. He has the burden of proof. He doesn't have evidence or witnesses to be able to carry that burden. The whole focus of the trial court's discussion at that point with counsel is on disclosures and the sanction provisions in Rule 26D. So that's where I don't think it is properly preserved. The trial court never even flushed out what is impeachment evidence. And neither has Utah law, frankly, on what constitutes impeachment evidence and can it be used just to challenge the veracity of a witness or used for other purposes. And I think you'll also note that in the appellant's opening brief, there's really not a whole lot of discussion of this impeachment question. It's not until the reply brief that counsel actually gets to federal cases. What does the federal courts do for impeachment, and other states, which leaves us in a very difficult position in having to present all of the argument information about impeachment at oral argument and not in our brief. And so, as a threshold matter, I don't believe the impeachment question alone is preserved.
Well, let me ask you about that, because I thought and it's been a while since I read the brief, so correct me if I'm wrong, but I had the impression that it was dealt with by the other side in the reply brief, primarily because you made it one of the focus points of your argument. Namely, this works just fine. To call the other side, and if you don't like the story you hear, all this other comes in by way of impeachment. So it seemed to me like you really drilled down on advancing that argument, in which event for Mr. Ahlstrom to join the issue in the reply brief doesn't seem wrong to me. What am I missing with that observation?
Well, and I don't know if I drilled down on it. I think all I did was mention that Utah really hasn't made a ruling or a decision or flushed out that impeachment issue. I think that's all I'd mentioned, that there's really only one case that I found that addresses impeachment and disclosures. What Mr. Ahlstrom did not do was focus, on how federal courts interpret it and why Utah should adopt that standard, and which is essentially what his reply brief does. So that's the only thing, but I understand the point for sure. So
Johansen has a question, it would appear.
Oh yes, sorry.
You can ignore my question and keep focusing on this point. I'll just let you know that this isn't where I'm going to focus my mind on this case, and so you might want to answer some questions in other areas, if that's okay.
Well, for sure. I want to focus on what you want.
All right. I'd like to talk about Rule 26. Just as a global overarching thing, do you concede that we should at least be concerned with parties completely blowing off disclosures?
Yes. I mean, I can't answer that in any other way.
I thought so. So I appreciate that concession. And that's what happened in this case, right?
The initial disclosures were not provided.
Right. Well, and no updates either. There are only pretrial disclosures, correct?
Correct. There was discussions of issues. I mean, in domestic cases, you have these, kind of a different procedural mechanism where you have a pretrial conference with the commissioner who says, what are the issues? What are we addressing? But yes, the disclosures, yes.
All right. Just let's talk about a few things. First, do you concede that the trial court got it wrong on who bears the burden to show harmlessness? The presumption of the rule is exclusion of the evidence, right? And if the court's going to make a finding of harmlessness, how, why, and in what universe should we foist that upon the innocent party as opposed to the blowing off party?
Well, I don't essentially agree that that's how the trial court did it. I mean, the trial court says, I'm going to allow Kathy to be called as a witness because I don't find any harm in her not being disclosed. She can't do discovery on herself. She can't depose herself. She can't subpoena her own documents. And that's
Can I interrupt you there? Because that raises this interesting question. Do you think that Rule 26A1A2 requires the designation of a party?
26A12?
Yeah. 26A1A2.
Oh, okay.
I'll help you. it says you got to list each fact witness, and that doesn't have any exception. And then to be clear, it says, and except for an adverse party, a summary of the expected testimony. So my reading, please tell me how I'm wrong, is that you have to identify each fact witness, and then for everybody except an adverse party, you also have to give us a summary. But if I'm reading that correct, while you don't have to give a summary of an adverse party, you do have to designate an adverse party. True or false?
True. That's how I read the rule.
Okay. So why does it say that if by definition, in every case ever to be, you really don't have to, because since they can't depose themselves or ask themselves questions, it would always be harmless, under your argument, I believe, not to designate an adverse party. Why does the rule even have it?
I mean, why does the rule even have it, I think, goes to the sanctions provision. If it's not done, because clearly it wasn't done, and there have been other cases where it wasn't done, a recent one, that Johansen versus Johansen Properties case that was just a few months ago.
In that, yeah. Mm-hmm.
So just
Judge Orr wrote the main opinion.
He did, and I reviewed that case, and I don't see much difference between that and this.
Did you catch his footnote that my concurrence is actually the holding on that part?
I didn't. No, yeah. But
well, yeah, we're familiar with that case. As to, I have three questions. You've answered one. The second one is documents. 26A1B says you have to provide a copy of all documents that you may offer. So not that you plan to, but you might, in your case in chief. Is there any exception to A1B for impeachment evidence?
No, there's not.
Okay. And as to A1, A2, there's no exception for impeachment either, correct? The way I read the rule is the only exception for impeachment is other witnesses. So other individuals.
Discoverable information.
Right, who might have discoverable information.
The only thing I'll note is that in this case, the judge let in all the documents. I mean, even Kathy's, who also were not disclosed. I mean, the trial judge didn't limit it to just Colton. He took all of the parties' documents and considered them.
Okay. But you agree that the only exception for impeachment under the rule is just for individuals likely to have discoverable evidence, right?
That's the only, yes, correct.
All right. But so we have this interesting tension, I guess, that on the one hand, you don't need to identify anybody likely to have discoverable information unless solely for impeachment. But in the next subsection, you do have to identify each fact witness you may call in your case in chief. So obviously the first one's broader. The focus then comes down to who's going to be called in your case in chief. So how does that then figure in with so-called impeachment witnesses?
Well, I think
you see where I'm going?
I do, for sure. Okay. Yes, that those
right.
witnesses were not designated.
Correct.
So I see that. So the way I see it is the trial court in each different case, because I don't, obviously the rule requires even an adverse party to be designated in initial disclosures. However, the trial court is afforded a substantial amount of deference in deciding what the sanction will be, whether to exclude all these witnesses that are now in the pretrial disclosures or not. And I think it is a case-by-case basis. Perhaps in a very complex property case or, a contract case, failure to designate the opposing party as a potential witness would be detrimental. In this case, the trial court found that it is a petition to modify based on cohabitation. Clearly, Kathy is listed in the petition to modify. Her paramour that she cohabitated with is listed by name in the petition to modify, and that provides significant, or not significant, but sufficient disclosure as to who will be called in this case. And that's what the trial court relied on when making its decision.
So the distinction is that in a complex case, the rules will be enforced, and in a non-complex case, ambush is invited.
No, but the trial court has the discretion to make that call, even if someone on this court would do it different. That's how I read the interpretation of the rules.
I realize the rule isn't written this way, and it may be that there's room for improvement here. But before this case came along and I focused specifically on the language, I had always sort of assumed that that exception for impeachment witnesses contemplated the situation where, as the trial unfolds, oh my gosh, who knew he was going to say that? Did not see that coming. So you get a witness to come in and say, I was in that same meeting and that's not what happened. So you would have had no opportunity to disclose that witness in advance because you didn't know there was the story was going to unfold that way and that you would have the need to impeach that witness. It seems like the thrust of the rule at least should be, if you know in advance that you've got a witness that's going to be called specifically for the purpose of impeaching one of the other side's witnesses. I mean, that seems like particularly important disclosure to make. We've got a witness who used to work with you and says you're a damn liar and have never told the truth in your life. Well, if you know you're going to call that person at trial, seems like they ought to be disclosed. But I recognize that the rule does not speak in terms of unanticipated impeachment evidence, but I'm a little concerned that the rule as drawn permits someone to have this bevy of impeachment witnesses available and then just spring them on everybody at trial. That does not seem to me sound practice, although I have to admit it may be consistent with the rule as drafted, depending on how broad that term impeachment has. Could you address that?
I agree completely, Your Honor. I think that, I mean, especially when it pertains to experts, because if you're going to designate an expert for rebuttal purposes, you have to disclose that. You can't, there's specific case law on that question. But I agree that that's not how the rule is drafted. I don't see that there's prior law that interprets impeachment evidence in that way. But I can see what you're saying, and I absolutely think that if that is the intent of the rule, then it probably should be modified in a certain way to have it say that. But that's certainly not how the trial court was basing this case on.
Judge Mortensen loves my footnotes. Maybe this would be an occasion for a footnote making such a suggestion, because otherwise, just to have that broad exception for impeachment evidence seems potentially quite inconsistent with the purpose and thrust of the rule. Less so in the case of unanticipated testimony. Oh my gosh, I didn't see that coming. We need to find somebody who can refute that. That kind of impeachment evidence, we're very used to that coming in sort of unannounced as people are doing their best to deal with the unexpected. But planned impeachment evidence seems like it ought to be on a different footing.
I have one last question. Mr. Richards, I hope you don't think I'm being too hard on you, but
No,
these
you're okay.
These cases cause me a little bit of consternation for this reason. How the fallout works out in this case is important to the parties, and I'm sure important to you. But the reason I'm being so probing is what we write down is taken to the bank by the bar, and anything we do to undermine what bright lines there might be, granted there's sometimes gray area, is a fraud exercise, because our opinions can be used in perpetuity as an excuse for underhandedness. Not that I'm not saying that happened here. I'm just saying in the future, people can kind of use it as a get out of jail free card, for want of a better term. But here's my last question. Do you agree that had the court under 26A1A little 2, little Roman numeral, excluded the respondent, Kathy, would any of the impeachment witnesses have been allowed?
No, I don't think so. I mean, that was the sole basis of his decision, and it was something the trial court, frankly, came up with. I mean, this was the trial court's solution to this, was that it was harmless not to designate Kathy. We're going to let her testify, and if she does not testify consistent with what, I mean, based on her testimony, I will allow impeachment.
Right, but that seems to me, just kind of unpacking it backwards, to be the quintessential definition of harm. Everything would have been excluded had the rule been followed, but because we found this threshold fact witness that should have been disclosed under 26A1A2, then everything else came in, kind of like a dam breaking. How is that not harm?
Well, I'm not. Well, again, the harm question I think only comes down to Kathy, and I understand unpacking it backwards. I mean, I understand the argument. I'm just saying this is how the trial court did it, and I don't see that it's inconsistent with any of the prior case law that on impeachment that under Rule 26D4, that if the party fails to disclose, that then the trial court has the discretion to either find harmlessness or good cause for the failure, or he could have excluded. And I don't think, and based on those two decisions, Segoda and the Hansen, Curry Jensen Properties case, I think the trial court had the discretion either way. And had he excluded Kathy, I don't think we would have an argument because of that substantial deference given to the trial court in looking at the facts of every specific individual case.
I'll tell our chair that I'm done.
Okay, very good.
Thank you.
Thank you, Mr. Richards. We appreciate your argument, and Mr. Ahlstrom will have the last word.
Thank you, Your Honors. I guess I would ask if you have now any new questions to level at me.
Apparently not.
Well,
not yet, let me say.
Well, I'm not certain what else to say in rebuttal, Your Honor. I think our position is that, well, it was covered during the first 10 minutes, and I don't know that I have anything further to add in rebuttal, other than perhaps to point out that we did address impeachment evidence in our opening brief on pages 15 and 16. And I think it's important for the court. I think it's important to define impeachment evidence and the fact that the phrase is solely for impeachment, which limits the type of evidence that can be presented. If it's evidence accomplishes multiple purposes, this rule says it's only those people who might have information about the case, unless they're solely for impeachment, which means exclusively. So the only purpose of their testimony would be to impeach. Only those people don't need to be disclosed. Otherwise, they need to be disclosed. And the rules, as the court has indicated, are designed to eliminate this whole idea of trial by ambush. So if what happened in the trial court is okay, then I think I've been practicing law wrong for the last 15 years. I do a lot of divorce work, Your Honor, and if I applied this approach to my divorce cases, then It would be, I think it would be bedlam and chaos. I don't see how that can work, but if it is, then perhaps that's going to your comment of being able to take a decision to the bank, but it suggests that I've been doing things wrong.
Well, you've got time left, because I often fight in saying when we're in the courtroom, the time allowed for rebuttal is a maximum. It's not a minimum.
Right.
And it sounds like we can ask Mr. Richards then to join us back on screen. We very much appreciate the arguments today. As you may or may not know, we do not routinely schedule every single case for oral argument. Only those cases where we think that oral argument will be of material assistance in our understanding of the case. And that was our thought here. And I for one, have found the arguments helpful indeed for that very purpose. So we thank you both for joining us today and for your arguments. We will, as is our custom, take the matter under advisement, let you have our decision in the form of a written opinion as soon as we're able to get that taken care of. And with that, we will stand in recess until our 10 o'clock matter. Thank you all.
Thank you all very much.
Thank you, Your Honor.